I walked into the Latah County Courthouse on Friday morning for the motion on the investigative genetic genealogy discovery. I've read all the motions, the supporting declarations, and so forth, and frankly didn't have a really good outlook on the likelihood of success for the defense on this request. I don't think they're going to get what they're asking for. But I have to tell you, after sitting through the hearing and what I heard, my opinion has changed, and I now think there is a much better chance that they may actually get some, if not most, of this information. So I'm going to tell you why. The challenge the defense has going into this motion is overcoming the state's argument that basically the IGG investigation is moot. They don't plan to use it at trial, and whether it was done correctly or incorrectly doesn't really matter, because at the end of the day, they got Bryan Kohberger's DNA from a cheek swab when they arrested him, and they have, according to the state, been able to match that DNA to the touch DNA that was found on the button of the knife sheath. So kind of a no harm, no foul type of situation. Why does it matter to go down this particular road? And so the defense, of course, has some answers for that. The main one, to me, from my perspective, is that they want to know how it fits into the investigation as a whole. They have a theory that the state had no suspicion of Bryan Kohberger until they got this tip from the investigative genetic genealogy investigation that they need to go look at him. And then once having identified him as a suspect, they work backwards to try to find things that make it look like he probably did it. So they find a white car in the area around a time that's maybe consistent-ish with the time of the murders. Look for evidence with the cell phone towers, the pinging, and so forth. Was he out and about that night? And basically use that to reverse engineer a case against Bryan Kohberger. This is, from my perspective, perfectly valid defense strategy, something that they need to explore. But the problem is they don't need all of the details of the IGG investigation to be able to make that argument. They don't need a family tree or the steps that were taken to build a family tree in order to be able to do that. They just need the timeline of when did the police receive the tip, and they can get that through other sources. You can just question Detective Payne, for example, and ask him, when did you get this particular tip from the investigative genetic genealogy research? So that argument, while it's strong, it's a strong defense argument, I don't think it really provided the justification for this information that the defense needed. The second reason is because they argue that the police may have done it wrong. They may have broken the rules. They may have violated the terms of service. We'll say, as an aside, it was pretty fascinating sitting in court on Friday and hearing an investigative genetic genealogist who does this work for the state giving the specific directions on how the state can work around the limitations these databases have in place to keep police from being able to access the profiles of people who have opted out. Kind of understood that those types of things can happen, but how simple and how pervasive it is was certainly not something that I knew. You don't hear that type of thing in court very often, so that was kind of interesting. But the problem there that I saw is that the defense just hasn't done a really good job of previewing the arguments for the court about why that matters from a legal perspective. There's a lot of potential problems with a challenge to investigative genetic genealogy because it's predicated on the violation of other people's rights besides the defendant, third parties' rights. And generally speaking, in constitutional law, you don't get to assert the rights of a third party for your own benefit. This is a concept called standing that basically says that you're limited to your own privacy violations if you're going to seek suppression of evidence in court. So that's a big problem that the defense is going to have to overcome if they want to challenge this process and make an argument that if the police violated the terms of service, if they went and accessed DNA that they didn't have a right to access, that is somehow a violation of Bryan Kohberger's personal privacy rights protected by the Constitution, such that he has a viable argument to move to suppress something. They didn't do a good job of previewing that. It's a very difficult argument to make, in part because this is an extremely novel technology. This is very cutting edge, not just from the technology side, but certainly from the legal side. And so the defense, I felt, needed to do a little bit more to draw out, for example, when the U.S. Supreme Court is originally looking at DNA analysis, surreptitious collection of DNA, discarded DNA, that type of thing, and the extent of people's privacy interests in their DNA, part of the justification for the Supreme Court's reasoning that generally those things are allowed is that because the specific type of profiling that the police are using is limited, it gives them very limited and not particularly personal information about the suspect, that's part of why there isn't a reasonable expectation that people can say, I didn't give you the consent to go and, analyze my genome and do that type of thing with my personal genetic information. Well, that's a completely different situation with this new technology where the profiles that are used contain an absolutely enormous amount of personal information about suspects. And so that's got a lot of trickle-down implications if law enforcement is allowed to just freely use this technology without any type of a warrant. Not to be too conspiratorial, but personally, I think there's a reason why the Department of Justice policy is currently that we're not going to use this evidence in court, because if you don't use it in court, it's a lot harder to challenge it legally. It's a lot harder to actually make law and actually look at these issues and see how they fit into the jurisprudence as a whole. So that could have been better previewed. I'm not trying to kick the defense or anything like that. They're extremely busy, and developing these types of arguments takes time. This is the sort of thing that I do for my work on appeal, and it really does require a lot of just brain space to let things percolate a little bit, to explore in your research things that you may not have thought about. When you're preparing for a trial, you don't really have the luxury of time and mental space to be able to do that. So I'm not trying to give them a hard time or blame them for not having this already, all sorted out in their briefing. But I'm just identifying that as a potential weakness I saw that led me to believe that, if they can't show the court why this would matter, why they would have a strong argument to suppress it anyway, then it makes it pretty unlikely to me that they would be allowed to access that information. So what changed my mind about how I think this motion has the potential to go? It had to do with the statistical evidence, the information that was presented about how these statistics work. So first off, there doesn't seem to be any dispute that when it comes to the actual laboratory processing of the sample, the development of the S&P profile, and that whole process, there doesn't seem to be really any dispute that the defense is entitled to and should get that. In fact, I believe the state conceded that they were going to go ahead and turn that part over because that fits within the scientific processes, tests, reports, etc., part of the discovery rule. But really what the state is trying to resist is the building out of the family tree, the part where the S&P profile then gets introduced into the database and the matches obtained and so forth. And that process that we heard about from the witnesses on Friday can take place. So they don't want to share that process. And the defense, I think, is rightfully suspicious. Why would you not want to do that? Probably, there's some problems with reliability of that information, problems with the terms of service, access, and so forth. So why would they potentially be entitled to the family trees? I thought the defense did a great job of presenting this argument through Stephen Mercer, the first witness that they called, who pointed out how it relates to the statistical modeling that the state uses when they present an STR profile. When the state is presenting evidence in court to say that this person's DNA was compared to DNA located at a crime scene, they attach a statistical likelihood, a probabilistic calculation to that being the same person. And basically the way that it is phrased is that the likelihood of it being somebody else is, 1 in a quadrillion, 1 in 10. I mean, it can be a wide range of statistical probabilities depending on, the quality of the DNA and probably other factors as well. So the state then has that power to be able to make it sound like it's almost certain that, this is that person's DNA based on that statistical calculation. And so what that expert, Stephen Mercer, pointed out is that those statistical calculations presume a universe where nobody else is related. And that's not the real world. The real world, everybody has relatives. Some people have a lot of them. Some people have fewer of them, but the extent to which you share DNA with other people in the general population is going to affect the likelihood that somebody else in the population could pop up with these same STR markers or substantially the same STR markers in their genetic profile as your suspect. So he made the point that when you develop that family tree, when you get that information from police, that's potentially going to relate to the likelihood of a false match, the likelihood that this statistical calculation is not credible, is not valid, because it's presuming nobody is related. But if in fact a lot of people are related, that can change that statistical calculation. So that's a very viable avenue for cross-examination for the defense. It's something that's extremely relevant at trial because we know the state is going to present this STR evidence. So for them to be able to adequately explore it, this is information that the state has that they are not realistically likely to be able to get themselves without, undue burden, going through the same process basically that the state has already done to get a sense of who Mr. Kohberger's relatives are, how many of them are out there, and that type of thing. So for that reason, that's why I've changed my perspective on this, because that witness was able to make that link between the information that the police got from the S&P profile and the evidence that they actually intend to introduce at court, the STR profile. That makes it relevant. That means it is no longer a moot question. It is information that could potentially bear directly on the viability of the state's case. Of course, I don't know how long we're going to have to wait for Judge to give us his decision. I would hope it's going to be soon. I'm sure the defense wants it to be soon. As I mentioned in my last video, I kind of suspect that might have something to do with our status hearing on Wednesday, because they need to know what they're working with before they can make the other decisions that have to be made in accordance with the schedule that the judge has set for this thing to go to trial on October the 2nd. So, don't know when we're going to find out, but I do think the judge kind of tipped his hand a little bit. At one point in the hearing, he made comments. I'm just going to paraphrase. I'm not going to try to quote him or anything, but basically what he's saying is that, look, if we're looking down the road to potential appeal, post-conviction relief, right, habeas corpus petitions, things like that, then it's in everybody's interest, really, that in marginal cases, he just go ahead and side with the defense, because then that takes away a potential argument that they could raise and a potential way to undo a conviction or a sentence. No judge wants to have to try this case a second time. And so that is, a pragmatic kind of approach to a criminal case like this. We talked about it too with Johnny Depp and Amber Heard, how from my perspective, saw a lot of Judge Azcarate bending over backwards for Amber Heard, because I think it would have been clear to expect who the more litigious party was and who was more likely to actually proceed with an appeal and try to raise issues and stuff. So it's a common practical perspective I think that judges have on the case. So before this hearing on Friday, I don't think it was really all that marginal. I think it was pretty clear that, yeah, there might be things, but might be is really not gonna get you where you need to be able to compel this discovery. But by making that link with the ability to challenge the state's evidence, the specific STR profile statistical calculation that we know they are going to present that at trial. There's no question about that. That is important. That's not so marginal anymore. So makes it a lot closer to an issue where makes sense to just go ahead and tip that in favor of the defense so they can't argue it later, now that they've made their record of what it has to do with what's actually going to be presented at trial. So we'll see what the judge decides, and when he decides it, of course, I'm going to keep my eyes open, but don't know if I'd go so far as to say, like, I would bet that the judge is going to do that. Depends on the odds you give me. I think that's still like an underdog position, but I do think it's a lot more likely than I thought it was when I walked into court. So hope that makes it clear what my thinking is on this motion. And if you have any questions, drop them in the comments. I will see you in the next one.